Hello, everybody, and welcome to today's event, Defending Immigrant Speech. I'm your host today, Taonga Leslie, and I'm Director of Policy and Program for Racial Justice at the American Constitution Society. Perhaps no two issues have defined the first 10 months of this term. And as I wrote that, I was shocked to realize we've only been in this term for 10 months. It feels like a lot longer. But perhaps two issues have defined this term more than the crackdown and rapid expansion of immigration enforcement, detention, and deportation, and the administration's growing willingness to use the tools of government to explicitly target speech that they disagree with. And we've seen these two issues intersect from the targeted deportations of pro-Palestine protesters like Mahmoud Khalil and Resma Ozturk, and also the weaponizing of threats against naturalized citizens like the recently elected mayor of New York, Zoran Mamdani, who the president has threatened to denaturalize. So it's a very pressing time, and this is something that ACS has been focused on, but we are proud to have two experts with us who have been looking at this issue from the scholarship and history and also the realities of an area of law that is rapidly being changed and tested before the courts. So for our first panelist, I'll introduce Alina Das. She's a professor of immigrant rights and the co-director of the Immigrant Rights Clinic at New York University. She's covered this issue both in the courtroom and through her scholarship for more than 2 decades for immigrants facing detention and deportation. Welcome and thank you for joining us, Professor Das.
Thanks for having me.
I'm so thrilled to have you. I want to start by looking at your scholarship because one of the things you've written about has actually started from the power of immigrant voices themselves, how they've been able to challenge and sometimes even secure changes to deportation and detention policies, and about how the government has retaliated to suppress that speech. And you started writing about this even during Trump 1.0.
Mhm.
So, before we get to sort of the current, I'd like you to lay out some of the themes of your scholarship about what you mean by the power of an immigrant voice, what some examples are of how that's been effective, and why is the government been motivated to suppress that speech?
Absolutely. So if you look at our immigration system today, we are certainly operating under laws that have been in place for decades, mostly unchanged by Congress, a set of very anti-immigrant laws that were passed in the mid 1990s. So essentially, any positive change that we've seen in the immigration system is really a result of immigrants who have been organizing to push back against negative policies and try to craft examples of ways that the government can actually do some good within the system. I think the strongest example of that is obviously the work that young, undocumented activists have done in pushing for programs like deferred action for childhood arrivals. We would never have had DACA as a program if it weren't for activists organizing in every possible way, obviously coming out into the streets and declaring themselves unapologetic and unafraid and trying to push those around them to stand up for people who are in their circumstances, but also doing other kinds of organizing within detention, organizing at the border, really pushing to, do the things that our First Amendment is designed to protect, to speak out and to ensure that other people, the American public, politicians, are really listening to what they have to say. And that is how they were able to push back against some of the deportation policies under the Obama administration and have President Obama adopt and roll out the DACA program. And that's one example. Certainly, we've seen it in other movements. The sanctuary movement is essentially a movement across lines of people who are citizens, people who are immigrants, people of faith who've come together protesting some of the policies we've seen. First around asylum seekers and discrimination against Central Americans, all the way to today for the criminalization. And so it's because those voices are powerful, because they are working, that we see suppression. We see efforts by the government to try and retaliate against people who have been speaking out. And that's certainly true. The immigrants obviously have many different identities. So in addition to fighting for immigrant rights, causes like the ones I've mentioned, there are also people who are part of various movements in this country, whether it's the pro-Palestinian protests that you've referenced, whether it's Black Lives Matter. Immigrants have been involved in these movements through these multiple identities alongside citizens. And so when we see the immigration system being weaponized as a tool to silence critics, that's when the alarm bells go off, and we try and use the First Amendment to protect those rights and come up against some of the challenges that we have whenever we're trying to fight detention and deportation, that there are laws in place that make it very difficult to have access to the courts.
And I wanted to double click on one of the examples you've written on because it was sort of novel to me. Like there's a lot of our focus because it's more out in the open is okay, preventing people from being detained. But you've also written about speech and dissent within detention. And can you say a little bit about that and what those folks have been fighting for and how that's been retaliated briefly?
Absolutely. So I think I've written about the way in which we can truly learn lessons from various abolition movements, in particular, the abolition movement to abolish slavery and the role that freedom of speech has played in that movement, that it was so critical to the success of that movement. And how much that resonates for modern day abolition movements, including the movement to abolish immigration detention. And often we're in a very difficult time right now with the massive expansion of detention. But the people who have been most effective at getting localities to change their mind about whether they're going to engage in contracts to detain people for immigration and customs enforcement, to shed light on abuses and things that are happening, are the people inside. So those detention centers are designed to shut out and shield people from public view. And so when immigrants engage in hunger strikes, when you sometimes will see these pictures that they'll post, in the small windows that they have outside of a prison or a jail, saying help, that they need help, or even in some of the prison yards where people will try to make signs and show the outside world what's happening, where they write petitions and grievances that get out to the public, they speak to the press. Those are the moments where we can capture the public's attention and bring people from the outside to those detention centers and call for their closure or call for the release of people in detention. And that's such an important part of the movement, because otherwise we're relying on the government to control the narrative, to say, oh no, we abide by standards. Oh, we're treating people well. And it's only the people inside who can really call that out. It's been an incredibly important part of the movement, and that's why we've documented that it's often suppressed over time, where you will have the government officials, jail officials react very violently in many cases to people who have tried to engage in peaceful hunger strikes, to lock them in solitary confinement, to abruptly transfer them to other facilities in order to essentially break up that collective action. And until we're able to truly listen to the voices of people who are in detention, we won't see that kind of momentum shift, the kind of power shifting we need. And it's a lesson that I think we've learned very much from other movements across time, that you really need people who are directly impacted to speak out. And that's very true of our prison and detention systems.
Well, then I want to get into the doctrine because an interesting wrinkle of the First Amendment is, of course, it doesn't mention citizenship at all. And this is something that the Supreme Court has said. At the same time, it seems that the Supreme Court has often been unwilling to practically enforce rights in the immigration context. Can you sort of explain what that is and what reasons there are for the court not maybe as vocally intervening in some of these major precedents?
Sure. So, and I think this goes to a broader issue within constitutional law. I'm seeing more and more debates in the courts, among academics, really giving credence to the questions about what constitutional rights non-citizens have in the United States. in ways that I think if you were really doing kind of an originalist analysis of the text, if you were looking at the First Amendment, you'd say it really truly doesn't matter what your status is. That's not what the First Amendment about. The First Amendment, in many ways, is really about curtailing the government from silencing people in any event, like regardless of citizenship. And that makes sense because the point is that we want a robust debate. We want people to decide for themselves what they think is right or wrong. That's how people can be the heart of our government. If the government is allowed to silence its critics, whether those are immigrants, whether they're any kind of particular group that happens to be disfavored in that time, then we don't have a free democracy. And so there's really no reason to look at the First Amendment and think, huh, I wonder if immigrants in this country are fully protected. And there is case law, as you mentioned, that recognizes that non-citizens have First Amendment rights and recognizes it in the context of immigration, of detention and deportation. That principle kind of wars with this other longstanding principle in case law that suggests that essentially Congress and the executive have a kind of plenary power over immigration, that courts should be very hesitant to intervene when Congress or the executive have exercised those powers, particularly around deportation and the border, that those are areas in which the government may have more say over rights. But if there's any kind of limit to that principle, I think the Constitution has a very significant role to play, and we certainly don't want a two-tiered system of freedom of speech in this country because that defeats the purpose. And so that principle, I think, we're actually still on fairly strong ground. But on top of that is another set of legally complex issues that have to do with when courts have the jurisdiction or the power to intervene in deportation cases at all. And that's where we're seeing more hesitancy on the courts, where they won't even reach the First Amendment issue because they think that there is a limitation on their ability to intervene in someone's deportation, for example. And there is a case that came out of the 1990s where the Supreme Court suggested that in a certain context, in a context where they bought into the idea that it was essentially a context about people engaged in support of terrorism, that there wasn't a right to challenge one's deportation based on selective enforcement, and that it wasn't clear that these individuals had any sort of First Amendment right that was being trampled on. There, of course, again, it's this context of terrorism, which always puts on an additional gloss that makes it difficult for people to face, to bring these challenges. But what we've seen is that from this perhaps narrow context, and there, even in that case, the Supreme Court recognized in a case of outrageous discrimination, there is an exception to their general rule against selective enforcement claims. That kind of case has been cited by the government in the more current context. And a lot of my scholarship really was developed because my own clients were facing this issue, where they themselves are immigrant rights activists who, during the first Trump administration, were detained because of their activism and were facing deportation because of their activism, where we were able to go to court and get the court to recognize that actually, no, in that kind of case, where a person is speaking out on immigrant rights issues or other issues involving core political speech, which is protected by the First Amendment, they absolutely can bring a claim to challenge their removal, and that a court does need to hear that claim. That particular principle is being tested today, which I know we'll talk more about. But it's incredibly important to know that even though there's some I think immigration law is pretty much old precedent that doesn't fit modern times, that's the challenge that we have today is to, again, normalize that immigrants absolutely have constitutional rights, including First Amendment rights, that courts should be hearing now, that you can't just put the First Amendment on pause for a deportation case, that really it turns the Constitution on its head and leaves out a critical part of our communities whose First Amendment rights are incredibly valuable.
Thank you so much. A lot to chew on, and thank you for laying the groundwork. We're now going to bring in Ramya Krishnan, who is a senior staff attorney at the Knight First Amendment Institute. She's also a lecturer at Columbia Law School. Her litigation focuses on protest and dissent, employer speech, and the digital public sphere. And also, she is leading litigation in I'm going to butcher this, American Association of University Professors versus Rubio, which won a pretty major ruling against the Trump administration's policy of targeting pro-Palestine protesters, especially non-citizens. So, Ramya, I want to invite you in because we've seen sort of the legal landscape and the obstacles that that Alina's laid out, and yet you also were able to, despite that, get this really bold, clear ruling that I think heartened a lot of folks at the end of last month. So I want to ask if you could just lay out for folks who may be less familiar what your client was, what the issues that arose, and sort of what the relief they were seeking against the government was.
Yeah, happy to do that. And thanks so much for having me as part of this great conversation. So we brought this lawsuit on behalf of the American Association of University Professors, the AAUP, and the Middle East Studies Association, which are both nationwide faculty-based associations that count among their membership not only tenured faculty, but also untenured faculty and grad students. So the AAUP is the nation's oldest and leading organization dedicated to promoting academic freedom and shared governance. And MESA, its mission is to foster academic discourse and scholarship focused on the Middle East. So we brought this lawsuit back in March, a few weeks after the arrest of Mahmoud Khalil. And by then, the administration had already made clear that Khalil's arrest was not a one-off. ICE had already arrested Georgetown postdoctoral fellow Badr Khan Suri outside of his Virginia home and forced Barnard student Yun Seo Chung into hiding. The very day we filed suit, Ramesa Ozturk, a Tufts student, was kidnapped by masked agents off a public street in Somerville, Massachusetts, and hustled into an unmarked van. And not long after we filed suit, Muhsin Madawi was arrested at a scheduled naturalization interview in Colchester, Vermont. And through all of this, the administration made clear that they were targeting people based on their speech and that more arrests were to come. So, as I'm sure many listeners know, these actions created just such an intense climate of fear and repression on college campuses across the country. Foreign students and faculty have been chilled in all sorts of ways. They're avoiding political protests, they're purging their social media. Many of them have stopped publishing scholarship or other forms of public writing that they believe could put them in the administration's crosshairs. Many are avoiding international travel, even when this travel is necessary to advance their study and research. And some have even been self-censoring in the classroom. What's more, US citizens have been unquestionably harmed by all of this because they are deprived of the very valuable insights and engagement of their non-citizen colleagues and students. And so we brought this lawsuit to end this climate of repression. And the central claim of the suit was that the administration's policy of ideological deportation violated the First Amendment because it was chilling non-citizens from speaking and by extension, robbing US citizens of their perspectives on what was an enormously important matter of public debate. We also argued that this policy violated the Administrative Procedure Act, both because it was contrary to constitutional right and also because it was arbitrary and capricious, which is to say, it was neither reasonable nor reasonably explained. So we had a 2-week trial in the summer where Judge Young, a judge on the federal district court in Massachusetts, heard extensive testimony, both from government officials who implemented the policy and from non-citizen scholars who are members of the plaintiff associations and who have been chilled by the administration's actions. And following that trial, Judge Young ruled in our favor on both claims. Critically, he found that the Secretaries of State and Homeland Security intentionally and in concert had engaged in a campaign of intimidation, a campaign that involved arresting, detaining, and deporting individuals like Mahmoud Khalil in order to chill. That is, with the intent of chilling pro-Palestinian speech and speech that is critical of Israel. He found that these officials and their agencies had embarked on this campaign, this policy, following President Trump's issuance of 2 executive orders early on in his administration, which target, among other things, anti-Semitism, what it terms hateful ideology, and support for terrorism. And he found that this policy was intentionally viewpoint discriminatory. It was an intentionally viewpoint discriminatory implementation of those executive orders, which is to say they were singling out pro-Palestinian and anti-Israel viewpoints for immigration enforcement. And having made those findings, he came to the central issue of the case, which, as he framed it, was whether non-citizens who are lawfully present in this country have the same First Amendment rights that citizens do. And he concluded emphatically that they do. So that was a really important ruling. And having reached that conclusion, his resolution of the First Amendment claim that we advanced in the case was pretty straightforward. He found that the administration's policy of ideological deportation was a brazen violation of non-citizens' free speech rights. So having received, having issued that ruling, we are now seeking a number of remedies. We are, of course, seeking relief that would block the administration from further implementing this policy of ideological deportation, as well as set aside relief under the APA, which is to say we're asking the court to vacate the policy. But we're also seeking a number of other measures, including notice and transparency requirements that we believe are necessary both to counteract the chill that has been effectuated by the administration's policy, but also to ensure the administration's compliance with the court's rulings. And we have a hearing on that issue now on December 15th.
Well, number one, fabulous work, and thank you for doing it and for bringing that case, and congratulations. One burning question that I have is, so there is, as Alina had mentioned, sort of a string of very unfortunate precedents going back to Turner, which is like an anti-socialist case. There's anti-communist cases from the 50s. And then the 90s case Alina mentioned actually was involving the Palestinian context as well. I'm curious how you dealt with those cases. Were they brought up by the government? And how did you and the court sort of navigate these cases where perhaps the Supreme Court has not been as emphatic as we might have hoped in the past, but still to come to this statement that he was able to issue in the present?
Yeah, so those cases definitely came up. The government in our case has, from the very outset, vigorously maintained that it has the authority to arrest, detain, and deport individuals based on their political viewpoints. The only cases they were able to marshal in support of that, frankly, astonishing argument, the cases that you mentioned, which emerged from the Red Scares. And Judge Young, quite rightly, found that those cases have been overtaken by modern First Amendment doctrine. And critically, Heresiades, so that's a case from the McCarthy era. It's a case that involved the attempted deportation of individuals who were affiliated with the Communist Party. And just to put the case in context, at that point in time, being a member of the Communist Party was not itself protected expression or association. So what the court was really saying in that case is that you can deport a non-citizen for engaging in expression or association that is not protected by the First Amendment. Of course, today, being a member of a political party, whether it's the Communist Party or the Democratic Party, is undoubtedly protected by the First Amendment. But even assuming that Heresiades is still good law, the conclusion that Judge Young reached in our case is entirely consistent with it, because modern First Amendment doctrine makes clear that the political advocacy that was at the heart of our case, which is to say, expressing support for Palestinian human rights or criticism of Israel, is protected. And attaching the labels, anti-Semitism or support for terrorism, is not an effective means of evading the First Amendment. It doesn't take something out of the land of protected speech.
Mm-hmm, mm-hmm. That is very helpful, and I'm also glad that you were able to just look at and say what seems to be obvious, but sometimes isn't obvious in law. Like, yeah, a lot has changed in 70 years for the better, and this is something we shouldn't just completely let go of within our circumstances. I want to bring you both in relatedly because it's sort of a thread I want to tease out for our audience. Like there's the on the face issue of which the government has been remarkably blatant here. We want to target people because of their ideological position, and that's the reason. But a related issue that's come up now, and that also Professor Adas has written on, is the selective prosecution question, where a minor typo, you forgot to put a certain grandparent on an application, which I think they've actually moved to in the Khalil case, I believe. And so despite these larger circumstances that make it clear that we're targeting you based on speech, now we're going to say that it's for some other neutral grounds. I was just curious if you could talk a little bit about that, about what it takes for courts to kind of look beyond the cover of that, and if that's sort of an area that we'll see the government move to next, if it becomes the norm that you can't, in the most blatant way, say we're targeting XYZ people.
No, I think it's really helpful to tease out that point because we are seeing various forms of First Amendment violations happening here. So you can certainly have a case where the government is kind of directly engaging in First Amendment retaliation, going after someone because of their speech. A lot of the issues that we've seen in Mahmoud Khalil's case and others really have to do with using an arcane ground of the Immigration and Nationality Act that explicitly is about saying like we are going after somebody and deporting them, despite the fact that we recognize that their speech is lawful. But that is a form of a First Amendment violation and a form of First Amendment retaliation. That isn't selective enforcement. It's not that they are finding like that they go after people on this ground all the time and they happen to pick someone because of their speech. It really does have the First Amendment issues at its core. Whereas the classic selective enforcement case is one, as you mentioned, where perhaps there are a million ways one can technically violate immigration law. The government often does not enforce those provisions, but then it chooses who to enforce because of a particular factor, and in this case would be their exercise of speech. So that was the case for the first client that I represented who had this issue, Ravi Ragbir, where he was somebody who had a final order of deportation. We do know the government does detain people and deport people who have final orders of deportation. But he, like hundreds of thousands of others in his circumstances, was actually given permission to stay. And the reason they revoked that permission was because of his speech. So that is kind of a classic selective enforcement claim where we're not saying that they don't have the power to do this at all, but we're saying the reasons that they chose were First Amendment retaliation in his case, and that they were selecting him. And that's what brings us into the heart of this the case, Reno versus AADC, and whether or not that's outrageous discrimination in that context. And we were successful in his case, and then we're ultimately able to settle his case, and he was able to find a path and now has his green card back. And we weren't ultimately did not have to litigate many of the thorny issues that come with that kind of litigation. But as you noted, it's also coming up in Mahmoud Khalil's case, who's also one of my clients, where in addition to relying on this ground of removal that is at its core First Amendment retaliation, they're also, they went back and are scouring applications and coming up with arguments that we think are wrong, but are arguments that actually we can also just deport him on a pretty vanilla ground of having misrepresented some information on his application as a green card holder. We know that this is still part of that same policy that Ramya and others are challenging. It's part of a policy of targeting people because of their speech. That's, again, that part is not selective enforcement, that the whole policy is a violation of the First Amendment, and this just stems from that. But even if you were to put that context aside, it's still unlawful, and it is a violation of the First Amendment for them to have decided to look at his application because of a First Amendment related reason, because he has spoken out in favor of Palestine and has made statements critical of Israel, that is not an appropriate ground for them to be going back on his application and using that as a pretext for his deportation. And so it's incredibly important in normal First Amendment world, if we take immigration out of this, it's always the case that you would want to be able to look at the actual reasons why some adverse event happened, even if the government has the power to do it. You can, if you work for the state and you're fired from your job, sure, maybe they can fire you for a million reasons, but they can't fire you because of your speech. Like, it is an impermissible reason. And so in many ways, we're just trying to normalize all sorts of First Amendment litigation in the context of immigration so that we don't have this kind of farce where they say, well, because it's an immigration reason, because we can go after you in general, it's okay for us to do this. And no one gets to look behind why the government has actually targeted someone. Because to the average person looking at Mahmoud's case or many of the other students and scholars who've been targeted, there's no guesswork. We know exactly what's happening. I mean, the president obviously has tweeted about it. They're doing it for this reason, and it absolutely creates a chill. That's the reality that we're living in, and that's why we need courts to be able to stand up, whether it's whatever kind of First Amendment violation is occurring, to not allow the government to get away with shielding their actions because of various doctrines in the immigration context that don't fit. These cases, ultimately, to me, I'm an immigration litigator, these aren't immigration cases. This is an abuse of the immigration system, which is already a horrific system, to achieve this retaliatory and punitive purpose. It could be some other system. It could be the tax system. It could be, it could be the criminal justice system. There are many systems in this country that the federal government seems willing to abuse when it goes after its critics and its perceived political enemies. And we need courts to be able to stand up and look behind that rather than accepting the government's pretext.
We're about a little more than halfway through, so I want to give folks the first CLE word. That word is poster, Poster, and you can find the CLE documentation and instructions on the same website where you registered for this. And I also think this is a good time to ask both of you, because we looked, of course, there's immigrant speech, and that's what this event is titled, but there's a thread that both of you have engaged with in constitutional law about the right of recipients of speech and how this implicates not only immigrant speakers, but also citizens, right, who are being cut off from access to information, whose movements and organizing are being suppressed sort of in conjunction with immigrant speakers. And I wonder if you could just say a little bit more about that doctrine, how it exists, and also how you engage with and what kind of arguments courts especially are receptive to when bringing up that thread of rights.
Yeah, I'm happy to kick things off. Yeah, I mean, the right to speak and the right to hear are deeply connected, and that is something the Supreme Court has recognized for some time in its cases. I mean, if the purpose of the First Amendment is to foster robust debate and discourse, as Alina mentioned earlier, then there is no way to have that discourse or dialogue unless you're protecting both the right to speak and also the right to receive information and ideas. I think that, you know, Justice Marshall put this best in a powerful dissent that he wrote in an ideological exclusion case, Klein against Mandel, where he says that the freedom to speak and the freedom to hear are two sides of the same coin. The coin is the process of thought and discussion, and in that process, you have speakers becoming listeners and listeners becoming speakers in what is this vital exchange of ideas that we have always understood as a hallmark of this democracy. And that's something that we tried to emphasize from the beginning of our case, that the administration's ideological deportation policy has systemic effects on the free speech environment. It isn't just non-citizen scholars and students who are being harmed here, it's their citizen colleagues and students who are also being harmed because they are no longer able to hear from teachers who have been chilled from teaching certain courses at all, or who have been forced to modify their syllabi in certain ways. You know, citizen teachers are being deprived of the valuable insights of foreign students who are too scared to speak up on certain topics in the classroom. So these are really systemic effects that these censorship campaigns have. And the Supreme Court, for what it's worth, has, I mean, Klein against Mandel, the case that I mentioned earlier, something that is significant about that case is, so I said it was an ideological exclusion case. It was about the admission of a scholar outside of the country, a foreign citizen, inside the country. He wanted to visit the country in order to attend and speak at various universities, to engage in dialogue with other faculty and students inside of the United States. And the court recognized there that although foreign citizens who are outside of the country have no First Amendment rights, people inside the country who want to hear from and receive the information and ideas of those speakers have a First Amendment right to hear from them. Now, how that shakes out in any particular case is, you know, complicated, particularly in the admission versus deportation context. But I think it's significant that the court has recognized that even where you have a non-citizen who does not have a First Amendment right to speak, people who are inside the United States still have a First Amendment right to hear.
Wonderful. That's really helpful. Yeah. This One thing that is coming up, sort of the meta, like even beyond this context, is this question of rule of law that we've been grappling with this year. And so many institutions being tested, and immigration is an interesting one because as you both pointed out, since the 90s, there has been sort of this attempt to even stop courts from intervening there. Alina, you've written about this as a place of lawlessness. And to everyone in our audience, I really hope you'll check out the ruling from Ramya's case, because the judge there actually included a photocopy of a post-it note from what it seemed to be an anonymous threat saying Trump's has pardons and tanks. What have you got? Sort of this very explicit challenge to the idea of courts playing any meaningful role in what's going on. So I'd ask both of you, what has working in this context taught you about the rule of law? And also, what does it take to get courts to engage and to think of themselves as having maybe a more active role in preserving rule of law than maybe they might want to have or would like to have in a time when it could be easier to just dodge things or not reach the merits or not address the broader context that we're in.
Yeah, no, it's such a great question. And yeah, and I loved reading Judge Young's opinion because you can tell, in addition to engaging with like the incredible record that the parties were able to put forth to really make the case that this, you can tell it struck a nerve with him as a human being watching what was happening, not only to students and scholars and non-citizens who were engaged in pro-Palestinian speech, but in the broader ethos of what it means to be someone trying to voice an opinion or express dissent, as there is at the same time a consolidation of power and a disrespect for the courts, particularly from the executive. And so I also highly recommend the decision to people who are interested in these issues, but also want to see an example of a court being willing to say things that need to be said from our legal institutions during a time like this. And I think that's true of several of the courts who've been asked, not all of them, but several of the courts that have been asked to weigh in on some of these newer issues, whether it is the retaliation against pro-Palestinian students and scholars, or on issues that are also feel new, or what was old is new again with the Alien Enemies Act and other just kind of egregious oversteps by the executive, to see when courts really are willing to go the extra mile, not only to issue a technical ruling on the law, but to put it in this larger context. Because I think that that is what we're in danger of losing. I'm sure there's a million reasons why a judge or a court will feel empowered to stand up and uphold the rule of law in these contexts, that have everything to do with the experiences of that judge, the issues that were presented to them in the case, the moment that they're in. But one factor that I've seen to be very effective across these contexts is actually the impact of the community in response to the things that are happening. So, when Ravi Ragbir was detained, along with other members of the sanctuary movement during the first Trump administration, there was a huge outpouring of community response and anguish on the streets as that was happening. And you had community members and members of the sanctuary movement, the faith community, would come to all of the court appearances, would speak out to the media despite the fear, and really crystallize the fact that this was a First Amendment issue, that this was a challenge to something very foundational, that the government story, the particular PR campaign at that moment, which was to say, nothing to see here, we're just enforcing immigration law, was not the actual story. And there was a targeted attack on movements. And that required there being a movement that courts could see very visibly. And I have no doubt that judges were impacted by seeing that, and to see that through amicus briefing, just through all of the different ways that people who are not parties to a case can express their outrage and their concern about what's happening. And that's true for what we've seen here as well. When you think about Mahmoud Khalil, hand in hand, I think about his wife videotaping his arrest and sharing that with the world, the way that people showed up at his hearings and have packed the courtrooms in his case. The reactions that other scholars have had, and in some cases, not all, the reaction of universities to say that they do not want to see their students treated this way, Tufts being a very positive example. When our public institutions kind of collectively stand up and say what they're seeing is wrong, that gives the judicial system like the power to stand on their own terms and to call out the executive and to, connect the dots in these opinions in ways that I think will resonate for history. Obviously, we're in a very uncertain world. Many of these issues we are seeing in the district courts will obviously percolate up, and it remains to be seen what will happen at that stage. But the through line has that happened in the first Trump administration too. That happened in Ravi Ragbir's case when it went up to the Supreme Court. It came back down, and we had to kind of start all over again fresh. We expect that, but what stays consistent is the community support, the community outrage, the insistence that the people are going to hold our institutions accountable. And that allows courts to intervene in the best way they can, when they can, even if there are going to be shifting tides and, reversals of decisions and perhaps, more consolidation of power. That's the give and take that makes our democracy what it is. And so I believe every legal victory at its heart, comes down to obviously the people who are directly impacted and then the communities who surround them and support.
Thank you. Do you have anything that you'd add to that, Ramya?
Not really. I mean, except to say that I think it has been significant that I think Alina is right, that there has been to a disturbing degree a certain amount of lawlessness that has pervaded sort of immigration law. But I think it's significant that even courts now, especially at the district court level, have been taken aback by the scale and brazenness of government officials' disregard of the law. Judge Young, for example, called the administration's conduct here virtually unknown to our constitutional tradition. He located that conduct in a sort of broader pattern of this administration attacking its perceived political enemies, whether those are law firms or higher education institutions or media organizations. And it was clear that he viewed all of these actions as very severe attacks on our democracy. And I think that one positive development that we've seen arising from just the egregiousness of the administration's conduct, both outside and inside of courtrooms, is this chipping away of the blind deference that courts have reflexively shown the government in the arenas of immigration, foreign policy, and national security.
Amazing. Well, we've got about 12 minutes left. I do want to get to at least a couple of these Q&A questions. Before I do, we've got the second CLE word, and that will be megaphone. So I'm putting that in the chat as well. First one was poster. And we'll start fielding these, so we'll try to move quickly. The first one we've got is, which we didn't reach in our main talk, is about the ICE retaliations that we've seen. What legal arguments are best advanced when ICE attacks people holding protest signs, especially around deportation raids and holding centers, but they're sort of at that distance, so not actively interfering with the proceedings?
Well, I mean, one thing to note is that unfortunately, the Supreme Court has really pulled back on recognizing a sort of right of action to seek damages against federal officials and agents. So it is unfortunately very difficult to seek accountability in that way. But as our case demonstrates, and there are other cases in the immigration context that I think do this as well, where you have the federal government engaged in a policy or practice of retaliation. And we've seen this across the Trump administrations. Alina spoke to these unfortunately widespread practice of retaliating against immigrant rights activists like Ravi Rugby during the first Trump administration. There are ways to hold the government accountable for what is clearly First Amendment retaliation, which is to say, officials and agencies retaliating against individuals, whether they are non-citizens or citizens, based on their protected political expression. So, ICE agents who are retaliating against individuals for holding signs, political signs they don't like, that's a clear violation of the First Amendment.
Yeah, and I will just add that it's both a law and organizing question. So I think as a whole, many legal organizations have put out guidance for protesters in terms of knowing their rights to ensure that they can protest, that they can hold signs. And what I think probably the person asking the question might be referring to is that that at many of these more recent protests, whether it's right outside of a raid or some of the courthouse arrests, almost because of the physical proximity, it becomes very easy for federal agents to essentially escalate the situation. You come there to hold a sign and to hold the agents accountable for something that's happening. And then there's some jostling involved, and suddenly people are getting arrested for obstruction or seeing more of those federal charges. So I think it's, for organizers, we've seen a really concerted, thoughtful effort to make sure that people who come to protests are aware of what their rights are so that they can escalate, to exercise them and avoid the escalation that we feel in many cases. It seems that federal immigration officials want to incur, like when they create a spectacle of arrest, because immigration arrests, unfortunately, have been happening, obviously, for many, many years, and they're usually done in a particular way, often out of sight. In some ways, this kind of desire to do this out in the open to create fear, it feels like it is part of a kind of an escalation strategy where they almost want there to be engagement so that they can accuse people of breaking the law. So knowledge is power in that context. And then when it does happen, certainly I think there's overreach in how they've been charging people. And we've seen everything from jury nullification to defenses being raised against prosecutions and things that are happening when the federal government is getting involved, particularly in the context of areas where they may be able to bring federal charges, such as in DC and other places, or if it's on federal property. So to the extent that that's a concern, I think many litigators are thinking ahead to how they can make sure people's rights are being enforced and to push back on that kind of overreach. But I do think organizers themselves have been doing an amazing job of making sure that the communities who show up are aware of how they can exercise these rights, because the worst consequence of all of this, and the consequence that perhaps the federal government wants, is for people to stop showing up. And that's the one thing we have to make sure never happens.
Mm-hmm. Moving to our next question. This one has referenced, so there's the arcane ground of the INA that the administration has used to start deportation processes against non-citizens. And I believe that the section being referenced is this idea that like the attorney general can designate a person for sort of whatever reasons. There don't seem to be many grounds for how that person is designated. This questioner says that Khalil has brought claims that should be declared void for vagueness, and is asking if you can elaborate on the strengths of that, and especially how that might be viewed in light of this plenary power doctrine, and that the way the courts have looked at immigration.
Yeah, so I appreciate the question. Obviously, I think it's very strong as a member of Mr. Khalil's legal team. So essentially, the foreign policy ground that is being challenged here, again, there's a version of this ground that has been in immigration law for a very long time. And, like our reading of the legislative history essentially is that at a certain point in time, it's been changed and tinkered with essentially because Congress has been embarrassed by the federal government sometimes using this provision to prevent people from coming to the US or staying in the US simply because of their speech. And so they wanted to ensure that the Secretary of State can make this particular designation and inform Congress when they really feel that there's a compelling need. And often that is in the context of somebody who is engaging in political work, often outside of the U.S., that has a direct impact on U.S. foreign policy with that country, and so that their presence here would be such a compelling foreign policy nightmare that they wanted to make sure that somebody very high up who would do things appropriately would have the power to make that decision, and that it wouldn't be left to low-level individuals, and it wouldn't be that you wouldn't be allowed to just trigger this for any reason. So whatever the thought is behind that, it's very rarely used and used in like very explosive political situations. What we're seeing now is this theory where you have Secretary Rubio making a determination. Actually doesn't even mention specific countries or what the foreign policy is. It talks about anti-Semitism as a general, concern that the United States has, and is punishing now people not for things that they may have done abroad or a emerging political crisis in a particular country that's affecting U.S. policy, but based on their speech here in the U.S. The fundamental idea behind challenging this as void for vagueness as applied to Mr. Khalil and others in his circumstance is that there's no way that you would know as a student, in his case, a lawful permanent resident on a college campus, that telling your university that you don't like the fact that they're supporting a conflict, that would suddenly be an issue that would subject you to deportation, that exercising your First Amendment rights on campus, as we often encourage students to exercise their voices, that would create such a political crisis that they could use this provision. And I think in Judge Farbiage's decision, he walks through very methodically the reasons why a person would never expect this provision to be exercised against them in this way. And if it is so vague to encompass like campus protest in the US, then it would create such a significant chilling effect that you do see this void for vagueness principle and the First Amendment issues merge, that is an area where we want our consequences to be super clear and super tailored, because if it creates a chill, then again, we're harming our First Amendment rights. And particularly when you imagine what's happening here on college campuses, it's an area of significant concern. So I feel very strongly that issue is clearly right on the law, and the fight will be more about whether and when that issue can be considered by courts. For us, it's incredibly important because of the First Amendment issues that it absolutely needs to be addressed now. You can't afford to wait and be under this heavy threat of deportation and the chilling effect that causes while your immigration case winds through the courts. That can't possibly be the way our judicial system works. It would mean that the First Amendment would be meaningless, at least for months or years. And at that point, do we really have a First Amendment at all?
That is excellent. I think I'll end us there. I really appreciate both of you. Thank you, Ramya. Thank you, Alina, for this fantastic and informative conversation. To the folks who are listening, especially members, I encourage you to check out our program guide. It's entirely about the First Amendment and the different attacks that we faced. And we've had a running series looking at a few different First Amendment issues. I also suggest folks check out a recent one we did on the rights of the press and journalists, because that certainly connects with this this issue of ICE retaliation and how we can face up to those threats. But thank you both. Folks, please check out the program list and stay tuned for our upcoming programs. and have a great rest of your afternoon. Bye.